Welcome to Seeking Disability, the show that helps you in seeking disability. I'm Tom Duncan of Duncan Disability Law.
And I'm Dana Duncan, president of Duncan Disability Law.
Dana, last time we talked about step 4, and we've been working our way through the sequential process to this point. Step 5 is where the majority of Social Security disability claims end up being denied. Now, past relevant work was step 4, and we've briefly touched on what step 5 is. It's an adjustment to other work in the national economy. Can you provide us with a better working definition of what exactly step 5 is?
So what ends up happening is the judge takes all the medical conditions that were not severe enough to meet a listing at step 3, as well as any other non-exertional or other limitations of non-severe nature that may have impacted work, and comes up with this residual functional capacity, which is the most you can do. He then presents that as a hypothetical question to a vocational expert. And for example, Mr. Vocational Expert, assume an individual limited to light work, which is defined as being able to lift 20 pounds occasionally, 10 pounds frequently, stand for 6 hours, sit for 6 hours, being able to push or pull 20 pounds occasionally. This individual would also be limited to occasional postural limits, such as stooping, bending, crouching, and crawling. The individual would have limitations in the ability to perform at a consistent work pace, but could do so within 2-hour segments. Would be limited to very few, if any, workplace changes. Would have no public contact, but only occasional contact with coworkers and supervisors. The vocational expert hears this and then testifies as to what jobs exist in the Dictionary of Occupational Titles that fit that job description. So, in other words, jobs that do not have limitations associated with the list in the hypothetical question. The vocational expert provides the DOT code and has to provide job numbers. How many of those jobs exist in the national economy? And it has to be a significant number. There is no good definition. It has to have kind of a rule of thumb as to how many in the national economy, and it differs from region of the country to region of the country. So that's in a nutshell how it's done. There may be multiple hypothetical questions. Ultimately, the ALJ decides which of the hypothetical questions is the residual functional capacity, and then generally adopts whatever the vocational testimony is for that limitation or set of limitations.
Now, to simplify that yet again, because I have to assume that most of you, if you have not been through a Social Security hearing yourself, or you are not a seasoned representative, has no idea what most of those phrases and or terms usually mean. Essentially, Social Security, because again, we're going back to our original definition that Social Security disability is whether or not you can maintain full-time competitive employment. This is measuring if you have a severe impairment, can you do your past relevant work? So we've gone through steps 2 and 4 there. Now, if you cannot do your past work, so you can't return to jobs that you've done previously based on your training and education and experience, can you do other jobs that might exist? So in this example, we've talked about different various jobs that may or may not be able to be performed anymore. Let's say we have a claimant who is a machinist and has been a machinist for 20 years, and all of a sudden they have a back injury. Social Security may not be able to prove that they can go back to the job that they were doing as a machinist based on the back injury that is involved. But they may be able to say, you might be able to do this other job where you're in a seated position based on your age, your ability to transfer different skills from one job to the next, etc. And so they are trying to prove, because at this point, the burden shifts from your ability to prove your case, but rather to Social Security, whether they can prove that you can still do work in a competitive full-time basis. And so they're trying to offer examples through the vocational expert testimony to counteract your allegations that you can no longer maintain full time competitive employment. So, with that in mind, they have to provide, as Dana mentioned, significant numbers of jobs either in the region where you live, which is not usually the case, or several regions of the country, meaning the national economy. Things they do not consider: whether the claimant would be hired or not. So just because you may, I don't know, your general disposition may not be pleasing, you may not be good on interviews, does not have any bearing on whether or not you might be able to do other work that exists. Let's say, for example, you are really nervous and you break down in every interview that you do for a job. That by itself is not something that would or would not matter in whether you were denied at step 5. We have also had a lot of people who do a lot of physical manual labor and they become a liability. Let's say they have a back injury or they injure their ankle or they have a specific physical injury that most companies would then look at if they're trying to go to jobs like what they did prior. And they might be told, no, I can't hire you. You're a liability for my workers' compensation insurance, essentially. That by itself is also not considered at this step. You may still be denied despite that situation. Other things they don't consider: whether the jobs are currently available or actually open. So, does an employer have an open job or position available for you to actually be hired in? That is not considered. And finally, whether the claimant lives near the job. Dad, have you ever had the job cited nut sorter?
I hear it in hearings all the time, but as far as I know, there are no nut sorters in Wisconsin. It's primarily in regions of the country that have nuts. And so they have pecans in Texas, they have peanuts in Georgia. That's where nut sorters are. Same thing. Cigar roller is a job that I hear once in a while. Well, there's only one place I know of that they have cigar rollers. That's in Florida because it's a large amount of Hispanic heritage people who learned the trade through their father or their grandfather and still roll cigars down in Miami. You're not going to see those all over. But if there's enough of them in the testimony of the vocational expert, suddenly you get found that you can be a cigar roller.
So, in essence, there are several things that common sense would dictate are not necessarily a further evidence of whether or not you might be able to do other work that are used against you. Social Security does not actually have a high bar to cross to prove that you might be able to do other work that exists. So, at this point, who is the only person that may be able to fight for you that knows what they're doing?
A trained representative who can point out that some of this stuff is absolutely bunk. Unfortunately, there are a lot of vocational experts who don't know what they're doing. And they're there because it pays a certain amount of money for almost no preparation or training. And you can sit there and make several $100s in a day just testifying at these hearings. And you don't have to do much else. You're just sitting there making, I think it's $150 per hearing, and you do 6 or 7 hearings in a day, and you go home and you've got a nice little paycheck. And so they don't prep, they don't spend any time, and they certainly do not understand half the time what they're testifying about.
Now, to be fair to some of the vocational experts, in a way that I have a feeling most claims representatives would not be in this particular instance, they're also put between somewhat of a rock and a hard place, adapting an outdated system with obsolete jobs to meet modern requirements and new technologies and somehow make this a fair process. Is that something that is fair to them?
No. And it's even worse because the job numbers from the Bureau of Labor Statistics are no longer organized by Dictionary of Occupational Title quotes. Yet the vocational expert has to provide job numbers per DOT code. And so they literally are using a system that does not match to come up with a number. And Social Security has been trying to figure out how to fix this for 20 years. I'm not exaggerating. It has been 20 years that they have been trying to fix this system, and they are no closer to getting it resolved than they were before. They just changed the rules a bit as to how it's supposed to be done. So the vocational experts tasked with, and I've used this phrase before, taking numbers of apples and telling you how many oranges there are.
Or taking 2 plus 7 and asking it how it equals apple.
Yes. And many of us who are well versed in this have ways of cross examining vocational experts to show problems in the testimony and that it's not reliable and therefore cannot be used to deny you benefits. And if the vocational expert it's shown that he does not or she does not understand what she's talking about, or that there's questions or flaws in the methodology for converting these numbers, the ALJ is not supposed to approve it. If the judge does approve it, then you have a case for appeal to higher bodies to overturn and say this is rubbish and we need to go back and redo this.
And how would you know whether or not you have an appealable issue?
Again, it's a representative that needs to be doing it, because our office does appeals, and we do them not only for our own clients, but we get clients who come to us after having been denied by other firms. We also have lots of clients who are sent to us by other firms after the representative lost at the hearing. So we see a lot of these cases, and we know what it takes to make a successful appeal.
So, given the outdated system, the difficulty of doing a vocational expert role, the complexity within the hearing itself, and relying by Social Security to prove that there are numbers of jobs, is this a good system?
It's abysmal, and it's only getting worse because Social Security was told they needed to fix it by the federal courts. So they came up with this system called the Occupation Requirement Survey that was supposed to replace the DOT. The problem is that when you use the Occupation Requirement Survey, the ORS, there are something like 150 variables that come into play. And there's a system that's established by the Bureau of Labor Statistics as to how you apply it. I'd say probably 80% of vocational experts have no idea what to do with it. They avoid it. So Social Security said it's available and we encourage you to use it, but vocational experts do not have to. They can use their training and experience and general knowledge of labor in the national economy to determine whether there are jobs or not. So the system Social Security said they came up with to replace it, the one that everybody told us for 20 years was going to do it, they don't want to use it. So therefore, they just make it so it's optional. So therefore, they can get around it. It is a horrible system. And primarily, the problem with the ORS, the Occupation Requirement Survey, is that if you have any kind of real impairments at sedentary, there aren't enough jobs in significant numbers left, because there's all kinds of deductions that have to be done for these types of jobs. And it's become a muddled mess. And quite frankly, I don't see most representatives properly cross examining on the ORS at hearing to show that these jobs cannot be performed as the vocational expert has testified.
Now, in your opinion, is this something that the average person might be able to navigate their way through?
There are a lot of representatives who cannot navigate through this. So
So,
they
no.
so no. Yes, that is exactly it. Because no.
Okay, so to recap here, step 5 is where the majority of Social Security cases are denied. It is Social Security's obligation to prove that you can adjust to other work that exists in the national economy. And they have created a system whereby it is a low bar for them to prove that. that they use vocational experts that are trying to rely on outdated systems and obsolete jobs and trying to do an equation that they are really not equipped or trained to actually be able to do, and coming up with a number that, for lack of a better term, is created to frustrate and screw over working people. And your only good method of trying to get your way through this system with as least resistance as possible is finding a experienced and knowledgeable representative.
That's about it. I think Social Security would avoid the term screwing over formerly working people. They would say that they're trying to justify why some people should continue trying to work. That's the euphemism that they love to use.
Now, if that hasn't made you completely discouraged about applying for disability entirely, next episode we will take you through all of the stages of what to expect in a Social Security disability claim and how somebody can help you through each one of these stages, because there are many different parts to a Social Security disability claim and case as it makes its way through both the system and possibly to the appellate court system. But we would encourage you, again, consult a representative. They are there to help you through these types of claims. And if you're concerned about cost, again, going back to our original episode, this is something that works on what's called a contingent fee basis, meaning that they can only collect fees if you are awarded disability. So on the front end, you won't owe anything initially to try and work through your case. It is the legal representative's job to try and get you awarded benefits so that they can receive a fee.
Correct. And it's only based on past benefits. Unlike personal injury law or some other areas, your future benefits cannot be touched by the representative. So we're limited on how much we can collect.
So we would encourage you, once you've consulted someone, to very carefully consider all of these things. These are just meant to inform you and not necessarily make you discouraged. Just knowing that there are a lot of complexities within the system, and it is our job to inform and give you options of your best way to navigate through all of this complexity.
Our office is designed to be convenient for you. We take care of most of this stuff. You should be checking with a representative as to how much the representative is going to be doing and how knowledgeable they are of all of this stuff, because we try to make it convenient for you so that you don't have to worry about it. You got enough dealing with your health. You don't need to be dealing with the government. That's what we do.
Of course, there's a lot more information to share, but that's a good place to stop for this episode. If you have more questions about disability, you can visit our website, duncandisability.com, or call 1-888-458-2406 to talk to the Duncan Disability staff. Thank you for listening. We'll see you next time. Seeking Disability is a production of Ronnie Duncan Studios. This show is written by Dana and Thomas Duncan. It is mixed, edited, and recorded by Thomas Duncan. Our music is thanks to Purple Planet Music. Our technical provider is Riverside FM, and our distributor is Captivate FM.